Indira Sawhney versus Union of India, 1992. Can there be reservation for other backward classes? Is the OBC reservation constitutionally valid? Indira Sawhney case upheld the constitutional validity of the office memorandum that provided 27% reservation to the backward classes. It held that the reservations should not exceed 50% and the reservation in promotion is constitutionally impermissible. In 1979, the Union government under Article 340 of the Constitution appointed the second Backward Classes Commission, famously known as Mandal Commission, to investigate the status of socially and educationally backward classes. The Commission, in its reports submitted in December 1980, identified 3,743 castes as SCBC and recommended 27% reservation in government jobs for them. In 1989, the newly elected Janata government issued an office memorandum to implement the recommendations in the report. Issuance of office memoranda was followed by the violent anti-reservation movement that rocked the country for 3 months. In 1990, a writ petition was filed on the behalf of the Supreme Court Bar Association challenging the validity of the office memorandum and for staying its operation. A 5-judges bench of the Supreme Court issued a stay order till the final disposal of the case. In the meantime, the Janata government collapsed and the newly elected government headed by Shri P.V. Narasimha Rao issued another OM on 25th September 1991. It introduced the economic criterion in granting reservation by giving preference to the poorer sections of SCBCs in the 27% quota. It also reserved another 10% of vacancies for economically backward sections who are not covered by any of the existing schemes of reservation. The 5-judges bench referred the case to the 9-judges bench. The bench issued a notice to the government to show the criteria upon which the government has proposed to make the 27% reservation. Arguments. Petitioners argued that the Mandal report perpetuates the evils of the caste system. According to them, the OM issued on the basis of the Mandal report, which is solely based on the caste criterion, is violative of Article 16(2). They demanded a fresh commission under Article 341 to make a fresh survey throughout the length and breadth of the country, as the Mandal report was based on the 1931 census and therefore it can never serve a correct basis for identifying the backward class. Another argument of the petitioners was that if the recommendations of the commission are implemented, it would result in demoralization and discontent and revitalization of the caste system. The petitioners submitted that the provision considered by Clause 4 of Article 16 can and should necessarily be made only by the legislative wing of the state and not the executive or any authority. The respondents contend that the Constitution guarantees liberty, equality, and fraternity for all classes of people, irrespective of their religion, community, caste, occupation, residence, or the like. To elevate backward classes to the positions of equality with the more fortunate, affluent, and enlightened sections of our country, it is necessary to provide reservations. After hearing the arguments of the petitioners and the respondents, the court held that first, Clause 4 of Article 16 is not an exception to Clause 1 of Article 16. The provision contemplated by Article 16, Clause 4 can also be made by the executive wing of the Union or of the state. Third, backward class of citizen in Article 16, Clause 4 can be identified on the basis of the caste and not only on economic basis. Exclusion of creamy layer is a social purpose. Article 16, Clause 4 permits the classification of backward classes into the backward classes and MBCs. The reservations contemplated in Clause 4 of Article 16 should not exceed 50%. Reservation in promotion is constitutionally impermissible. The judgment laid down a reasonable solution to the problem of reservation. The court made an attempt to balance between the interests of society and educationally backward classes. However, some opinioned that the court should have taken into consideration the interest of the poor section that is not covered by any of the existing schemes of reservation.